We've just been hearing from the minority push that the Attorney General and the President should respond to the key concerns raised by the Chief Justice. But the process in itself for removal is a legal process. Will their interference not be in breach of the Constitution? Educate us.
So, the President and the Attorney General have no constitutional obligation to respond to matters that will be outside of the constitutional framework. Nowhere in Article 146 is there a place, for such exchanges. Once the President has set up a committee and the committee is working, the President has nothing to do, until the committee has submitted its work. The Attorney General acts, upon the directives or instructions of the President. And here, the President must respect and abide, by the constitutional arrangement regarding the CJ removal process in pursuance of Article 146. What I see here is that there's a leadership crisis in the MPP. Since the death of Darocha, Peter Lajete, Odrisite, and Haruna Eteku, the MPP have been without an able leader. The party seems to be in complete disarray, and therefore the minority trying to make ugly noises here and there to create an impression that the MPP is still a viable party and a force to reckon with. But in so doing, they are tearing themselves apart and doing things that are unconstitutional. I've had occasion to point out that during the tenure of the presidency of former President Nanado, he bastardized the judiciary. And what the minority is seeking to do is to attempt to repair a damage that was left by their former leaders. That whatever they do, they should remember that the Constitution expects respect and unalloyed obeisance. That is, what the law says. The law says that, the rule of law requires careful tending. They must tend the constitutional arrangements regarding the CJ removal process, by virtue of what the framers put in Article 146. All of us should respect it. The President should not respond. Should the President respond, he will be violating, the oath, the presidential oath that, he subscribed and pledged before the people of Ghana that he will always defend and uphold the Constitution. The Attorney General, has no constitutional support in responding to something that, should not, be heeded. Both should respect the constitutional arrangement. As far as I'm concerned, the demand by the minority is like an erring child, who needs parental attention. If they have no father, they should go back, to, the party office, go back to the boardroom and see where they have faulted and repair the damage internally, rather than, seeking to plunge, the whole nation into some constitutional mess. That shouldn't be. And you shouldn't lend, your support at all to giving them audience, in the media, not at all.
But is it not a legitimate call for the AG and the President to respond to some of these key concerns, especially because she has raised concerns that the committee set up to look into her petitions have not even furnished her with the documents? So she's sailing blind, really. Let's go back to the Constitution. Is that standard procedure?
The Constitution has spelled out clearly the constitutional pathway with regard to the CJ removal process under Article 146. The leadership was not obliged, to respond if she had not been furnished with a copy. But the fact that her leadership has appeared before the committee, grounded in her response to the president and what was fed the Council of State, means that she has been supplied with whatever, she needed to be supplied before, she made her first appearance. It is too late in the day for her to somersault and tell the whole nation that, she's there to be supplied. I don't buy that. Secondly, nowhere in Article 146 is there a room for what, the CJ is now demanding. Absolutely, non-existent. Number 3, the Constitution does not admit of extra judicial rantings of the nature that is going on currently. Things like a political football field. What is happening is that once Article 146 is triggered and the committee commences its proceedings, it's like a court. So you don't appear before a judge, go back, to the general public and complain to the public, general public that, the judge is not, hearing your side. You have to, the rule is that if that is the case, you wait. And then, at the end of the judicial exercise, you may apply for judicial review and have, the proceedings quashed, or you may go on appeal or both. But you cannot complain, that publicly that you are being given a raw deal, and then next time you go back, to the court. So what the minority and the CJ are doing is unconstitutional. And it's a trap. It's a trap which the president and the attorney general must ensure they don't fall in. Because should the president respond, he will be in contravention of the Constitution, and he would have broken the oath of fidelity that he subscribed to in upholding the rule of law, which is the cornerstone of his administration. The attorney general must be mindful of his responsibilities in accordance with Article 88, Clause 1 of the 1992 Constitution. You go back and look at Article 88, 1 and 2, and you will see that his fidelity is to the Constitution. Indeed, in throwing out the CJ's deep injunction application, Tanko Amadou, JSC, in concluding his judicial sayings in that case, said that he owes allegiance to the Constitution and only to the Constitution and the Constitution only, and that he was going to abide by the oath he subscribed to the general public on the day, he swore, before the president that his fidelity to the Constitution will be absolute, regardless of, any, whoever's case is before the Supreme. I think that is the way to go. The minority should remember that this mess was caused by the MPP, and they will not listen, to, the general public. They didn't have a listening ear. If they had had a listening ear, they would have, withdrawn the nomination of Torkornoo when, some of us said that, she was being taken out of 10 and it was going to create problems for her, problems for the nation. And today, all of us are being, thrown into this unnecessary, political game. You and I had no hand, in what Nanado did, but today we have, to be responding, to what the minority, they made their bed, they must lie in it.
Okay, can the Chief Justice be held in contempt of the whole process, knowing fully well that the law allows that this whole process be shrouded in secrecy?
I don't think so. I have always said that once a court makes a pronouncement, there's nothing like being in contempt. It is part of the protection accorded, the citizenry in Article 21, freedom of speech. But if the case is sub judice, then, but if once the case is, pending, but a ruling has been made, you can comment on the ruling because it has been made. And the judge, the judge is functions official. And if that is, our understanding, the leadership, is free, to express itself on what are, the rulings that have been made, but not in contemplation or anticipation of a future ruling. So we should draw a distinction between rulings that have been made and rulings that are yet to be made. Once the ruling has been made or a judgment given, the court, have finished its judicial function, and the general public are, encouraged even to comment. This is how democracy goes. This is how the judiciary gets strengthened, because the judiciary is the last bastion and hope of the citizenry. And therefore, in accordance with Article 125, 1 and 2, the citizens must be allowed, to participate in the law-making and judicial-making processes. That is how, we develop, grow, and strengthen our legal institutions. So I don't think that he will be in contempt. He is not in contempt.
Now, they say the wheel of justice grinds slowly, but in our part of the world, it appears to be slower. We're hearing from someone who heads Ghana's judicial system, telling us that she's being treated wrongly. What is the fate of our judicial system in the light of some of these things that have come up?
Well, I'm happy that, no other person than the Chief Justice of the Republic has publicly acknowledged that we have a broken judicial system, on our hands. I'm very, very happy, that this has, been acknowledged publicly. And therefore, the criticisms of the judiciary, the allegations of corruption, the fact that, the executive and, some judges are always in bed, it's no longer a perception, but a reality. If it is real, then this is the time. So, Chief Justice Torkornoo, has given us hope that after this wake-up call, something will be done, to fix the broken system. The judiciary, thinks at the moment, and if nothing is done, it will continue to think, even from a distance, and that is not, in our best interest.
But from where you sit, what can really be done to break the broken system?
Well, I think the general citizen, in fact, the whole state, all of us must, search our individual consciences. We need some introspection, 100% introspection, to find, what has gone wrong. You see, the giver and the taker, the, governance aspect, the administrators, the media. So we have now 4 estates. We have the legislature, the judiciary, the executive, and the press. Now, these 4 have failed, the nation. And the ones, the 4 branches or arms of government have failed the nation. The general citizenry, comes to be at their beck and call. And therefore, when they realize that all is not going well, then they join them. So if you can't, beat them, join them. So unless, we change our attitude, so what we must do now is to overhaul, our attitude. We need attitudinal change. We need to understand that when it comes, to our institutions of governance, our cultural, perspectives in making certain demands should be, relegated completely to the background and allow the system to work. So you are frustrated. The Chief Justice is not frustrated. And, all that she's doing now, come out, of a Chief Justice who is frustrated. So today she says this, tomorrow she says that. It shows that even the Chief Justice is at the receiving end, of the, the broken system. And she, as I said yesterday, has supervised this for nearly 3 years. Is she now complaining? When was this the first time that she realized that the system of delivering justice in Ghana is broken and must be fixed? So let us now, wake up from our slumber and, as it were, as a people, collectively, take some surgery, carry out, the surgical operation of the judicial system. Not only the judicial system, the political system, the legislative system, the press system. All these things, need to be refixed. And we cannot, we cannot isolate one. Once you isolate the judiciary, you left, the other hanging, and the problem will not stop. Let us change our attitude and accept, reality. Don't let us say that, this one is a perception. And when you become a victim, you play. You should, constantly stand guard, over our governance. And the governance institutions are suffering, from lack of resources. They are, suffering from transparency. People get appointed not because, they are qualified, but because they know somebody somewhere, and the Constitutional Review Commission or Committee must ensure that Article 69 is losing. Article 69 is causing all these problems.
Okay.
The president has, too much power. The president appoints and appoints a conservancy laborer. That is, what is worrying us today. So if Article 69 is, modified such that, the too much power given to the president is kept, we take some back, and then, we fix our, appointing systems, like the CJ must be appointed by a system that is totally isolated from the presidency. You see that, we begin to make some, move.
Thank you so much. We appreciate your time.